A cross-examination is the lawyer's opportunity to ask questions of a witness that's called by the other side. And so the point of cross-examination is really to build the lawyer's own case through that witness, or to undermine the credibility of the witness. And so you may say, well, witness, I understand that you told the court today that the light was red, but you also told the officer at the scene that the light was green at the time that the accident happened. The key to cross-examination is to use leading questions, and that means that the lawyer really is leading the witness towards a certain answer. And so as an example, the lawyer might say to the witness something like, "Witness, you told the police officer at the scene that the light was green at the time of the accident, didn't you?" And so the idea is that you're going to get the witness to agree with you and say yes, and then that's helping you to make your client's case by the witness's answers and also by the question. In the first few times you do a cross-examination, you probably don't want to ask a witness a question if you don't know the answer. Once you get a little bit more experience, there might be times when you would want to use that, but for the most part, you should know the answer to the question you're asking.
All right, will counsel be cross-examining Mr. Wong?
Yes, Your Honor.
All right, go ahead.
Good morning, Your Honor. I'm Ms. Lau, and today I'll be asking Mr. Wong a couple questions.
Morning.
Mr. Wong, you are the youth leader at the local rec center, is that correct?
Yeah, that's correct.
And therefore you do know Mr. Donovan Tissey quite well, don't you?
Yeah, I do know him.
Mr. Tissey plays basketball at the rec center quite often, doesn't he?
Yeah, 2-3 times a week, yeah.
And he's quite good at this sport, is he?
Yeah, I wouldn't play against him.
Mr. Dwayne Dirks also comes to the community center, doesn't he?
Yeah, he started coming in late 2009-ish, yeah.
And Mr. Dirks does cause trouble at the rec center, is that correct?
Yes, he is rude to the other youth as well as myself and other staff.
And you've seen Mr. Tissey associating with Mr. Dirk, haven't you?
I've seen Donovan hang around with Mr. Dirks, once in a while, yeah.
And since they've been associating with each other, you've noticed a change in Mr. Tissey's attitude, is that correct?
Yes, Donovan just act a little more withdrawn, a little less interested in people, a very minor change in his attitude.
So he has been less interested in people, but he's also been rude to others, hasn't he?
I've seen him maybe mouth off once or twice.
To other youths?
To other youths, yes, sorry.
Now, the community center was quite busy in March, is that correct?
Yeah, it's busy in March.
And you work 5 days a week, don't you?
Yeah, I do.
You work from 2 p.m. to 10 p.m., is that correct?
Those are my work hours.
And you don't keep a record of the people who come into the rec center, do you?
No, I don't.
As a defense witness, you did not need to give the police a statement ahead of time, is that correct?
No.
Therefore, your recollection of the date in question is solely based on your preparation for this trial, is that correct?
Yes.
The date in question, March 10th, 2010, that's quite a while ago, isn't it?
It's around 2 months, yeah.
And since then, you've seen a lot of kids at the rec center, is that correct?
For my job, that's right, yeah.
So you can't be sure that you saw Mr. Tissey on March 10th, 2010, can you?
Well, I can be sure because I remember getting that specific information on March 10th, and I was very lucky to tell Donovan about it that afternoon.
So that you remember the exact day you received that form, the exact day you gave Donovan that form?
Yes, because it is scholarship and college information. It's not like I get it every single day. This was a lucky break.
You don't give other kids scholarship information?
Oh, I do try, but I remember that I usually have to give him at some other point, but I remember this day, I remember it because I got it that day, and I remember telling him that afternoon. It's very fortunate.
So can you please state the exact time you saw Mr. Tissey on that day?
You know, like I said before, I cannot be 100% sure, but it had to be definitely before 8 o'clock, because that's when I eat.
And you haven't recently seen Mr. Dirks, have you?
No, I haven't seen Mr. Dirks around.
Thank you, Mr. Wong. Thank you, Your Honor.
Well, in a criminal trial, the defense is asked if they want to lead evidence because it's the Crown's burden to prove its case. So at the end of all of the Crown's evidence, it may be the case that the Crown hasn't met the burden of proof and hasn't established that the accused is guilty. And at that point, the defense could simply say that it believes the accused has not been, that the Crown, I should say, has not proved the accused to be guilty, and stop right there and not lead any evidence. Well, in a mock trial, the defense will always lead evidence because it's an opportunity really for the students to conduct a trial of their own, and so they want to take advantage of that opportunity but it's important for the students to remind the judge that it is the Crown's burden, and so even though the defense is leading evidence, they want to remind the judge at some point that the Crown is the one who has to prove that the accused is guilty, not the accused doesn't have to prove he or she isn't guilty. When the judge asks if the defense plans to lead evidence in a mock trial, the defense should always say yes. So the next thing that happens is the defense calls its witnesses and the Crown gets an opportunity to cross-examine each of them. Direct examination is the lawyer's opportunity to ask questions of a witness who the lawyer themselves is calling as their witness, which just means that it's a witness who they think will be helpful to their case. And when a lawyer is conducting direct examination, they really want to ask the witness questions to allow the witness to tell the whole story and allow the witness to be what you might think of as the star of the show and someone who can really explain to the judge what happened. The key to direct examination for the lawyer is to use open-ended questions, and the best way to think about that is really questions that begin with who, what, where, when, and why. And that allows the witness to be the one who gives the information rather than the lawyer.
Good morning, Your Honor. My name is Mr. Bozis, and I will be
morning.
conducting the direct examination of Constable Rachel DiCarlo.
All right, go ahead.
Can you please state your name for the court?
Rachel DiCarlo.
And what is your current profession?
I am enforced by the Toronto Police Service.
And what division are you located at?
13th Division.
Where is 13th Division located?
It is located near Eglinton Avenue in Toronto.
I see you have brought your police notes with you. Were they written at the time of the event?
Yes, they were.
And are they in your own handwriting?
Yes, they
Are they in pen or pencil?
They're in pen.
Have you made any additions, deletions, or corrections?
None at all.
Do you have an independent recollection of the events?
I do.
And do you need your notes to refresh your memory?
Yes, I do.
Your Honor, may Constable DiCarlo use her notes to refresh her memory?
Does the defense have any objections to the constable using her notes to refresh your memory?
No, Your Honor, no objections.
Thank you.
I'm going to take you back to the evening of March 10th, 2010. What were you doing at approximately 7 o'clock p.m.?
At about 7 o'clock, I was called down to inspect an assault and a robbery near Eglinton Avenue.
Can you describe the crime scene and its surroundings?
Well, about 10 meters before the alleyway, there was a lamppost facing down, and there was also ample lighting from surrounding buildings from the alleyway.
And after you investigated at the crime scene, what was the next stage in your investigation?
Well, the next day, on March 10th, I went to, March 11th, I was called down to the hospital to see the victim, Andrew Williams, in hospital.
And can you describe the appearance of Mr. Williams at the time of the interview?
Well, he was bruised, black eyes, broken nose. He was bandaged up on his ribs and lying on the hospital bed.
And what happened during this interview?
Well, I obtained a full report from Mr. Williams.
After the interview, what happened next in your investigation?
On April 9th, I received a phone call from the principal of Tomorrow Secondary School, and she was calling regarding an individual at the school.
Just one moment, please.
Objection, Your Honor.
And what is the basis for your objection?
The evidence is hearsay.
All right, any response?
Yes, Your Honor. This is basically part of the narrative as to why Donovan Tizzy is a suspect and why he was further sought out to be questioned. And also, the rumors aren't going to be used for the truth of the matter. It's just basically for the narrative as to why he was suspected.
All right, I'm prepared to admit the evidence as part of the narrative to explain the officer's actions and what happened, but not for the truth of the contents.
Thank you,
Go
Your
ahead.
Honor.
Thank you.
All right.
So, okay. And why did the principal contact you?
Well, she contacted me because there was a student at the school, and there's rumors about this student that they had assaulted and robbed a younger youth earlier on and stole their basketball shoes.
And who was the student in question?
It was Donovan Tizzy.
Was any further action taken?
Yes, to see and to clarify whether or not Donovan Tizzy was in the alleyway, I made a photo lineup so Amber could pick out whether or not Donovan was in it.
And how did you construct this photo lineup?
Well, basically the photo lineup had 6 individuals, all male, and they had similar characteristics such as jawline, facial features, hair color, eye color, and skin tone.
And did Mr. William recognize anyone in this photo lineup?
Yes, he picked out, his first choice was Donovan Tizzy.
Okay. And what happened on April 10th, 2010?
Well, I went to the apartment building of Donovan Tizzy to ask him a few questions, and outside of the apartment, I did find a pair of basketball shoes that matched the exact description of Andrew Williams' stolen basketball shoes.
And can you describe these basketball shoes?
Well, they were high tops, and they were black, white, and red.
Your Honor, may I please approach the witness?
Go ahead.
Are these the basketball shoes that you obtained?
Yes, they are.
Your Honor, may these be entered as an exhibit as the witness has identified them as the stolen goods?
Any objection?
No objection, Your Honor.
All right, thank you. Go ahead. Those will be entered as an exhibit then.
And what happened next after you entered the apartment complex?
Well, I arrested Donovan Tizzy for assault causing bodily harm and for robbery. And as we were leaving the apartment, I picked up the basketball shoes and put them in a sealed evidence bag. And I put them in my locker until I brought them to court today as evidence.
Okay, no further questions, Your Honor.
Often during the course of a trial, a lawyer will have either a physical piece of evidence, like for example, something from the crime scene, or they'll have an exhibit that's a document, a contract, or something like that. And the way that gets introduced is there has to be a witness there who can identify the exhibit or the piece of evidence for the court, say what it is, where it came from, and really show the court that it is what the lawyer says it is. And then the court will mark it as an exhibit, which just means to give it a number and an official little tag that shows that it's an exhibit, and then it becomes part of the court's record.
Are these the basketball shoes that you obtained?
Yes, they are.
Your Honor, may these be entered as an exhibit as the witness has identified them as the stolen goods?
Any objection?
No objection, Your Honor.
All right, thank you. Go ahead. Those will be entered as an exhibit then.
Often during the course of a trial, a lawyer will have either a physical piece of evidence, like for example, something from the crime scene, or they'll have an exhibit that's a document, a contract, or something like that. And the way that gets introduced is there has to be a witness there who can identify the exhibit or the piece of evidence for the court, say what it is, where it came from, and really show the court that it is what the lawyer says it is. And then the court will mark it as an exhibit, which just means to give it a number and an official little tag that shows that it's an exhibit, and then it becomes part of the court's record.
Are these the basketball shoes that you obtained?
Yes, they are.
Your Honor, may these be entered as an exhibit as the witness has identified them as the stolen goods?
Any objection?
No objection, Your Honor.
All right, thank you. Go ahead. Those will be entered as an exhibit then.
At the end of the closing statements, the judge will stand up and bow to the lawyers. The lawyers will also stand up, bow back to the judge, and the judge will leave the courtroom. And then the judge will often come back in and give the lawyers feedback, which is one of the most important parts of the mock trial. Gives the judge an opportunity to say to the lawyers what worked and what didn't work, and give them some tips for future experiences that they might have. And the judge will occasionally in a mock trial either give a decision or give the lawyer some sense of the way that they were leaning in terms of making a decision. But the important thing to remember is that in a mock trial, it's really not a win or a lose kind of situation. What you're really doing is getting the experience, and often the judge's decision will be just a result of the facts that you're given and not something that you did right or wrong. So it's important to just take away from the experience the tips that the judge gives you.
Thank you, counsel, for your assistance. I'm going to take a break of a few moments to consider the evidence as well as your closing arguments, and I will return in a few moments' time and render a verdict.
All rise, please. Court is recessed. Order in the court, all rise. Court is now reconvened. Please be seated.
Okay, I'd like to thank all of you for your patience, and I would like to commend counsel for the very able jobs that you did. At this point, I would ordinarily give a detailed review and assessment of all the evidence. However, given the nature of this exercise, I am going to be very brief. Mr. Donovan Tissey has been charged with robbery and assault causing bodily harm. In particular, it is alleged that on the evening of March 10th, 2010, Mr. Tissey and another individual brutally attacked Mr. Enver Williams and stole his running shoes. In order for Mr. Tissey to be found guilty of these offenses, the Crown must establish the essential elements of each of these two offenses beyond a reasonable doubt. I have no doubt that Mr. Williams was indeed assaulted and robbed the evening of March 10th. The sole issue in this case is whether it was Mr. Tissey who was one of the two individuals who was responsible. I do not question Mr. Williams' credibility. However, there are inherent frailties to eyewitness identification, notwithstanding that the identification is honestly made. There is an unfortunate record in this country of cases in which individuals have been wrongfully convicted on the basis of eyewitness testimony. The court, therefore, must be very cautious in relying on this testimony alone as a basis for a finding of guilt. I also found Mr. Wong to be a credible witness. I accept his testimony that he indeed did see Mr. Williams on the evening of March 10th at some point before 8 p.m. It is possible that Mr. Tissey would have both been in the alleyway the evening of March 10th, encountered Mr. Williams at that time, and then gone on to the recreation center, at which point he saw Mr. Wong. However, there was no evidence before me as to the time it would take to get from Mr. Tissey's home to the recreation center, except for Mr. Tissey's evidence. I appreciate that Mr. Williams had a horrible experience the evening of March 10th. It is understandable that he would want to see the perpetrator called to account. However, our criminal justice system requires that before someone can be found guilty of a criminal offense, their guilt must be established beyond a reasonable doubt. In the circumstances of this case, based on the evidence that I heard, I conclude that the Crown has not established its case beyond a reasonable doubt. Mr. Tissey, I would ask you to stand now. I therefore find you not guilty of the two offenses with which you have been charged. You are free to leave. Thank you.
All rise, please. Court is adjourned for the day.
An objection is when one of the lawyers has a complaint about a question that's asked by the other lawyer or about some of the evidence that one of the witnesses is going to give. And some of the common objections that you might hear are when the witness is about to give evidence that's hearsay, or when the question is irrelevant, or you might hear a lawyer object if a question in direct examination is leading, because in direct examination you can't ask a question that suggests an answer to a witness. Or finally, you might hear a lawyer object if they feel that the other lawyer is badgering the witness, which is probably something you're familiar with from TV, where the lawyer just keeps hammering away at the witness with the same question without giving the witness a chance to answer it, or just keeping because the lawyer doesn't like the answer. So when you have an objection to make, the first thing you want to do is stand up and wait for the judge to recognize that you've stood up. And then once the judge turns to you and gives you an opportunity to speak, you make your objection. and then the other lawyer might respond to the objection and say why they think the question is relevant or why it isn't leading or something like that. And there may be an opportunity for you to respond to that. And the key thing to remember is that all of the exchange should go through the judge. So the two lawyers aren't talking to each other. They're always speaking to the judge. After the judge has ruled on an objection, then the lawyer who made the objection sits down and the examination continues in accordance with the judge's ruling. There's no further opportunity to argue about it. Objections are difficult both for the lawyers and for the judges because it's something that you're doing on the fly. So you really have to respond to the question that's being asked or the evidence that's being given without having much opportunity to think about it. Have to decide whether it's something you're comfortable with or you have a complaint about, and then stand up and object. And the judge has to decide on the fly whether they think it's acceptable, either the question or the evidence is acceptable, and then rule on it. So it's really difficult for everybody involved. The idea is that you'll get a fair bit better at objections the more trials you do, because you'll have more experience and you'll be more used to understanding what types of questions and what type of evidence is acceptable and what isn't.
An individual at the school.
Just one moment, please.
Objection, Your Honor.
And what is the basis for your objection?
The evidence is hearsay.
All right, any response?
Yes, Your Honor. This is basically part of the narrative as to why Donovan Tizzy is a suspect and why he was further sought out to be questioned. And also, the rumors aren't going to be used for the truth of the matter. It's just basically for the narrative as to why he was suspected.
All right, I'm prepared to admit the evidence as part of the narrative to explain the officer's actions and what happened, but not for the truth of the contents.
Thank you,
Go
Your
ahead.
Honor.
Thank you.
When court starts, the first thing that you'll see is the judge will walk in and everyone will stand up. You'll also see all of the lawyers and hopefully the people who are in the gallery to watch the trial bow to the judge. The judge will return their bow as a sign of mutual respect, and then the bailiff or the court registrar will ask everyone to be seated and advise everyone that court has started. The judge may then have some questions about the process for the lawyers, about where things are at and whether they're ready to start, and then the trial will start.
Order in the court. All rise, please. Court is now in session. Please be seated.
Good morning, everyone. My name is Justice Herman. If counsel could please introduce themselves.
Good morning, Your Honor. My name is Lau, first initial M, and these are my colleagues from the Crown. This is Martinson's, first initial P, Bozis, first initial J, Baker, first initial H.
Good morning.
Good morning, Your Honor. My name is Sultan, first initial S, and these are my colleagues from the defense. This is Cole, first initial S, Gulshan, first initial S, and Bigford, first initial J.
Good morning, everyone. And Mr. TC, is he here? Good morning, sir. All right. Are there any issues that counsel wish to raise before we get started? No? All right. Thank you.
The opening statement is the lawyer's first opportunity to tell the judge what they think about the case, what their theory is, what evidence they expect the judge will hear, and generally advise the court of how they see things unfolding in the case. The opening statement includes an explanation by the lawyers to the judge of what evidence they expect to call, which includes both documents or exhibits they might introduce and also witnesses who the judge might hear from and what the lawyers expect those witnesses to say.
All right. And do you wish to make an opening statement?
Yes.
Okay, go ahead.
Okay, good afternoon, Your Honor. My name is Bigford, first initial J. Okay, Your Honor, this is a case of mistaken identity. On the evening of March 10, 2010, our client, Donovan Tizzy, was at his local recreation center playing pickup basketball and spoke to the youth leader of the center about post-secondary and scholarship information. He was not in the alley when Mr. Williams was assaulted and robbed. Our client, Mr. Tizzy, is a 16-year-old youth in grade 10. While he was convicted of shoplifting 18 months ago, he has put his life in order and is on the right path. Mr. Tizzy has a part-time job, he is doing well in school, he is looking into going to college for technology and applying for scholarships. He also goes to the homework club and plays basketball 3 times a week at his local recreation center. It is anticipated that Mr. Tizzy will say he wouldn't assault and rob another youth and jeopardize his future. Today you will hear from 2 defense witnesses, Donovan Tizzy and Stephen Wong. We anticipate that Mr. Tizzy will describe that on the night in question, at about 6:00 p.m., he and his friend, Dwayne Dirks, left his apartment because he was upset about not being able to buy a new pair of basketball shoes. When prompted by his friend to steal the shoes from a store, Mr. Tizzy declined because he didn't want to jeopardize his part-time job and decided to do something constructive by spending the evening playing basketball at the local recreation center. We will also hear from Mr. Tizzy that during the evening he spoke to the youth leader of the recreation center about different college courses and scholarships. And at about 8:30 p.m., he left the recreation center by himself and walked straight home. Finally, Mr. Tizzy will describe to the court that about a month later, a police officer knocked on his apartment door and told him he was under arrest for assault causing bodily harm and robbery. The officer then picked up a pair of basketball shoes outside of Mr. Tizzy's apartment building and not inside his actual dwelling, and didn't bother to ask Mr. Tizzy about them. We anticipate that Mr. Tizzy will say he had never seen the shoes before. Our second witness, Stephen Wong, will explain that on the night in question, he was working at the recreation center and spoke to Mr. Tizzy about information on college courses and scholarships. We anticipate that Mr. Wong will describe how Mr. Tizzy's mannerism was during their discussion. We will also hear from Mr. Wong about his relationship with Mr. Tizzy and how often he sees him at the recreation center. We also anticipate that Mr. Wong will say that Mr. Tizzy has never displayed violent activity at the recreation center. Mr. Wong will also explain to the courts his particular role at the center.
All right, thank you.
The defense will now call its first witness, Mr. Tizzy, to the stand.
At a criminal trial, you'll see police officers using their notes to refresh their memory, and the reason that they're allowed to do that is, first of all, that the notes are made generally right at the time that the incident happens, and so the officers are doing their best to record exactly what they saw and what happened, and second, because they do have so many investigations that they're conducting, that it's difficult for them to remember the details of every single one, so it's easier if they can write it all down at the time and then use their notes later at the trial. And those notes that you see an officer using have all been disclosed to the counsel for the accused before the trial starts, and so there's nothing that comes up that's surprising to the accused, and they have an opportunity to prepare for and conduct their own examination.
I see you have brought your police notes with you. Were they written at the time of the event?
Yes, they were.
And are they in your own handwriting?
Yes, they
Are they in pen or pencil?
They're in pen.
Have you made any additions, deletions, or corrections?
None at all.
Do you have an independent recollection of the events?
I do.
And do you need your notes to refresh your memory?
Yes, I do.
Your Honor, may Constable DiCarlo use her notes to refresh her memory?
Does the defense have any objections to the constable using her notes to refresh her memory?
No, Your Honor, no objections.
Thank you.
I'm going to take you back to the evening of March 10th, 2010.
The first thing that a witness will do when they're brought to the witness stand is to be sworn in, and what that means really is that the witness is promising to tell the truth. The witness can do that in a few ways. They can either place their hand on a holy book, either the Bible or the Torah or some other holy book, and swear to tell the truth, or the witness can simply affirm to tell the truth, which is generally done if the witness prefers not to use a holy book.
Morning, sir.
Would you please state your name for the court?
Devon Tinsey,
Could you please spell your first and last name?
Dovantisi.
Would you like to affirm or swear on the holy book?
Swear in the book.
Do you swear that the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated.
Stephen and Just Wendy Reed were shot and killed on the Marsh Loop Trail on April 18th of 2022, just before 3 p.m. You will learn that they left their apartment in Alton Woods and went for a walk. And you will learn that they never came home. And they never came home because the defendant, Logan Clegg, murdered them. After the defendant murdered Stephen and Jeswendi, who loved ones called Wendy, he dragged their bodies off the trail to conceal them so no one would find them. He concealed their bodies and covered them in layers of leaves, debris, and sticks. And after he murdered them, he ran and he hid. He left Concord right after having contact with investigators who were searching for Stephen and Wendy. He left Concord and was out of the state for multiple months. And despite efforts to conceal his murders, and despite efforts to conceal his tracks, investigators uncovered those tracks. And they found him in South Burlington, Vermont. And when he couldn't run or hide, he lied. He lied when investigators caught up with him. He claimed he wasn't in Concord on April 18th. He claimed he never heard of the alias Arthur Kelly, the name that he gave to investigators when they had contact with him when they started their missing person investigation. He claimed he never had a gun in Concord. And when investigators caught up with him and they found him, he had a 9mm handgun in his backpack. He had over $7,000 in cash. He had a fake Romanian passport and a one-way ticket to Berlin, Germany. During trial, you will hear about how after Stephen and Wendy were reported missing, investigators spent months trying to solve their murders. The investigation was extensive and thorough. They discovered the defendant's identity through surveillance footage and through various purchases that he had made using prepaid gift cards. When they discovered his identity, you will learn that he was on probation for felony convictions. During trial, you will see and hear evidence for yourselves that will prove beyond any reasonable doubt that he is guilty of second-degree murder for killing Stephen and Wendy, and the other charges that you heard read today: felon in possession of a firearm and falsifying physical evidence for his efforts to conceal the murders that he committed. As you heard in jury selection, motive is not an element of the crimes charged. The elements are what you will hear presented during this trial. The state is required to prove that the defendant knowingly shot and killed Stephen and Wendy Reed. The evidence you will hear will show what happened to Stephen and Wendy and how they were shot and killed on the Marsh Loop Trail, and how the defendant is the one and only person who committed those murders. By the end of trial, you will know beyond any reasonable doubt that the defendant, Logan Clegg, is the one and only person who was responsible for the murders of Stephen and Wendy. The evidence in this case will show that the defendant murdered Stephen and Wendy, that he dragged and concealed their bodies, that he ran after having contact with investigators who were searching for Stephen and Wendy. He hid out of state in South Burlington, Vermont. He attempted to flee the country, and when he was finally caught, he lied. On April 18th of 2022, Stephen and Wendy went out for a walk near their apartment complex. Stephen's last known communication with family was around 11 a.m. that morning. When Stephen didn't show up 2 days later on the 20th for a regular tennis match, family members became concerned. It was unusual for Stephen not to show up and not to communicate. And you'll learn that Sue Forey, Stephen's sister, went to their apartment complex to check on them. They lived in Alton Woods on Loudon Road here in Concord. They lived in apartment 1411, so building 14. Stephen and Wendy's cars were out front when Sue Forey showed up. They weren't home. Their house was orderly. Their personal belongings were still home. Car keys, cash, wallets, Wendy's cell phones. What you'll learn is Stephen's cell phone was not home. It was not at the apartment. On April 20th of 2022, Sue Forey contacted the police. Members of the Concord Police Department and New Hampshire State Police started a missing person investigation to search for Stephen and Wendy. That same evening, so the 20th of April of 2022, while investigators are out searching nearby areas, nearby Alton Woods, they come across a tent nearby, near their Marsh Loop Trail. In this top area of this wooded area. And the blue is Stephen and Wendy's apartment. And they came across this tent, and they found a man in that tent. That man was a white man in his 20s or 30s. He had brown hair, and he was clean shaven. Investigators noticed around his tent many Mountain Dew cans. They spoke with that man, and he claimed his name was Arthur Kelly. He claimed that he was from Boston, Massachusetts. He was told that they were looking for Stephen and Wendy. He said he didn't see anyone else around. And investigators left the tent site, and they continued to search for Stephen and Wendy. You will learn that Stephen and Wendy's bodies were found dragged off the Marsh Loop Trail. The following day, on April 21st of 2022. Using location data from Stephen's cell phone and with the help of a canine, they were able to find Stephen and Wendy. Their bodies were concealed in the woods. They were covered by sticks and leaves and debris. Only a small portion of Wendy's head and her hair was even visible once the canine helped them locate them. Stephen and Wendy both had gunshot wounds, multiple gunshot wounds. Wendy had 2 shots to her head and her neck. Fragments were later, from those bullets, able to be recovered. Stephen had multiple shots to his left hand, his left arm, his shoulder, neck area, and his back. fragments from the bullets were able to be recovered. And autopsy results, which are the external and the internal examination of their bodies by the medical examiner, revealed that they died from gunshot wounds. After killing Stephen and Wendy, the defendant dragged their bodies off the trail down to the place where he ultimately concealed them. You will learn that investigators found blood and bullet fragments on the trail. Along the path between the trail and where Stephen and Wendy's bodies were found, a bloody pill bottle and a ripped portion of Wendy's green pants were found. The blood was Wendy's blood. During various searches over the course of the investigation, investigators later found shell casings at the crime scene, and shell casings at a location later discovered to be the defendant's burnt tent site. The day after Stephen and Wendy's bodies were found, so the following day, April 22nd of 2022, a woman named Nan Nutt came forward. Nan had described being on the Marsh Loop Trail on the same day as Stephen and Wendy, so the 18th. She recalled who she later learned was Stephen and Wendy were on the trail at the same time. She arrived at the Portsmouth Street, so Nan Nutt arrived at the Portsmouth Street parking lot, which you will see on today's view. She arrived at about 2:45 p.m. on the 18th. She started her hike with her two dogs. It was about 2:48 p.m. And what you're seeing on the screen are screenshots from Nan Nutt's cell phone tracking her hike. When Nan Nutt arrived at the Marsh Loop Trail, she recalled letting the couple walk past her. She and her dogs were going much slower. And she described that the couple that she saw appeared to know each other. They were having a conversation, and they appeared to be wearing clothing consistent with hiking. About 5 minutes later, Nan Nutt hears multiple gunshots. Gunshots that were further into the woods than she was. She thought that it sounded like a handgun, not a rifle. Initially, she didn't know what to make of it, contemplating that it wasn't hunting season. Ultimately, she decided to keep walking and hiking with her dogs. So she continues on with her hike. And as she continues on, she sees a man. A man who was looking off the trail in a direction that you will learn was in the direction that Stephen and Wendy's bodies were later found. The man Nan Nutt saw was a white man in his 20s or 30s. He had brown hair. He was clean shaven. He was wearing a blue sweatshirt or jacket and a black backpack. And he was carrying a brown grocery bag. Nan Nutt recalled the brown grocery bag having some type of cylindrical object in it. She wasn't quite sure what it was, but it was some type of cylindrical object. She didn't have any communication with this man. He kept walking in the opposite direction of her, and she kept going in her hike. She looked back to get a better look at him. And when she did, he was staring at her. She kept on her hike, and she left with her dogs. A few minutes later into her hike, she approached a different, older gentleman. They exchanged some words, and they both continued on their hike. Nan continued her hike until about 3:39 p.m., when she left the Portsmouth Street parking lot. With the information from Nan Nutt, investigators spent months combing through surveillance footage and receipts from nearby stores, trying to conduct multiple searches of the scene and nearby areas. You will learn during the course of trial that the defendant was living in a tent nearby. Circling the profile area on the Marsh Loop Trail map that you're seeing. When investigators went to the location of the defendant's tent, they found debris of a burnt tent site, consistent with someone living there for months. In the burnt tent site, investigators located shell casings, burnt grocery bags, Mountain Dew, along with burnt clothing. They also found about 150 mini burnt propane tanks. Investigators searched the closest located retail stores that would sell Mountain Dew and mini propane tanks. And investigators discovered receipts for almost all 150 propane tanks that they found, all purchased by Logan Clegg, the defendant. You'll learn that the defendant purchased propane tanks all winter in Concord. Investigators located months of surveillance footage capturing the defendant at Walmart on Loudon Road in Concord. The day after Stephen and Wendy were murdered, so April 19th of 2022, the defendant entered Walmart at about 9:40 a.m. He purchased a tent, a sleeping bag, and rubbing alcohol. You will learn that the same person who spoke with investigators and claimed to be Arthur Kelly was identified as the defendant, Logan Clegg. Investigators also found surveillance footage of the defendant on the day of the murders, just shortly before the murders. He was captured on cameras at Shaw's in Loudon Road, which you'll see today, is just a short walk. The Shaw's is at the bottom of the screen, and the Marsh Loop Trail is here. The defendant was seen at the Shaw's just before 2:30 p.m. at that Shaw's. In the surveillance footage, a white man in his 20s or 30s. He was wearing a dark blue jacket or sweatshirt, carrying a black backpack, and a brown grocery bag. Just before Stephen and Wendy were murdered. You will learn that when he left Shaw's, he walked in the direction of where Stephen and Wendy were murdered on the Marsh Loop Trail. These are all locations that you will see later today. The defendant ran after having contact with investigators. Just hours after having spoken to investigators who said that they were searching for Stephen and Wendy, hours after, he lied that he was Arthur Kelly. The defendant created an email account the morning of April 21st of 2022. That morning, he created a Gmail account, dentkelly0707@gmail.com. What you will learn is that he used that Gmail account to purchase a bus ticket out of Concord using another fake name, Denton Kelly. The defendant took a bus and got out of Concord, and he ran away from his crimes. A couple days later, when investigators went back to the tent site where they had encountered the man who claimed to be Arthur Kelly, they found no tent, no debris, no Mountain Dew cans, no trace of a tent. Over the next few months, the defendant continued to run. You will learn that he purchased a Greyhound bus ticket, a bus ticket that was scheduled to leave on May 15th of 2022 from Boston, Massachusetts to Burlington, Vermont. And when he did that, he used the alias Arthur Kelly and the Gmail account dentkelly0707@gmail.com. The defendant hid out of state and he attempted to flee the country. In October of 2022, investigators learned that the defendant, using the name Logan Clegg, had purchased a plane ticket, a one-way plane ticket from JFK Airport to Berlin, Germany. The flight was scheduled to leave in a few days. In this information, in this purchase, the defendant used a phone number that you will learn was tied to the email account firstpeterblack@gmail.com. Yet another alias and another email account. The defendant's flight was scheduled to leave on October 14th of 2022 from JFK to Berlin, Germany. Investigators obtained location information for that phone number. And location information revealed that it was believed to be in South Burlington, Vermont. You will learn that investigators traveled to South Burlington, Vermont, and they located the defendant outside a local grocery store, Price Chopper, where he had been working. And when they located him, they followed him to the public library. At the public library, he was using his laptop. He had with him a black backpack. Investigators made contact with him, secured his backpack, secured the laptop, and in the backpack they found a 9mm handgun. A handgun that he purchased using the name Arthur Kelly. A handgun that he purchased on February 12th of 2022 in Vermont. In the defendant's backpack, they also found a fake passport with his photo on it, which had been mailed to him at Arthur Kelly in Vermont. You will learn that bullets fired from the defendant's 9mm handgun in his backpack were consistent in caliber and class characteristics as bullet fragments found during autopsy. The shell casings from the crime scene at the trail and the defendant's burnt tent site were sent to the New Hampshire State Police Forensic Laboratory for ballistics testing. The analysis determined that those casings were fired from the defendant's 9mm handgun. When investigators searched the defendant's laptop, they found the same photograph that was used on his fake Romanian passport. They also found that he had conducted multiple Windows 10 procedures known as a fresh start. So just hours after having been questioned by the investigators who were searching for Stephen and Wendy, and he lied about being Arthur Kelly, he conducted fresh starts of his computer on April 21st of 2022. You will learn that a fresh start is a procedure that effectively wipes browser history, among other things. What limited search history available on his laptop revealed, search is consistent with traveling out of the country. And he also searched Concord NH News. He searched Concord NH News that same morning that investigators had contact with him, October 12th of 2022. When the defendant was finally caught, he lied. Investigators conducted an interview of him on October 12th of 2022. During the interview, he claimed he was not in Concord on April 18th of 2022. He claimed that he had left Concord in February or March. He claimed he didn't use a tent while in Concord. He claimed that he didn't stay in the wooded area near Alton Woods or the wooded area along the Marsh Loop Trail. He even denied knowing the name Arthur Kelly. He denied having a gun. And you will learn that despite being confronted with the information that investigators had learned over the months-long investigation, the defendant continued to try to conceal his murders. In the end, it doesn't matter what you call him. Arthur Kelly, Denton Kelly, Peter Black. What you will know at the end of trial is that he is all the same person, Logan Clegg. The same one and only person who is responsible for the murders of Stephen and Wendy Reed. The one and only person who shot and killed them on the Marsh Loop Trail. The one and only person who concealed their bodies and dragged them off the trail so no one would find them. The one and only person who burned his tent site, wiped information from his laptop, and bought a one-way ticket out of the country. After the defendant murdered Stephen and Wendy, he tried to run and hide. And when he couldn't run or hide anymore, he lied. The end of trial, we are going to ask you to find him guilty. Guilty of the crimes that he committed. Being a felon in possession of a gun, falsifying evidence for concealing Stephen and Wendy's bodies, burning his tent site, wiping his laptop, and murdering Stephen and Wendy Reed.